Okay, well, just I'll give the whole stage to Sander, and I think there will be enough room for questions and all that. I will be on the side with the mic because it's always nicer if you have the mic because the other ones can hear you as well. So have a nice afternoon with Sander.
Yes, thank you for that kind introduction. Just have to check whether this works. It doesn't, but it works manually. So, yes, as introduced, I think the name The Dance Lawyer is always like a bit of a thingy, but this explains why. This was 2015, a long time ago though. So I was playing at Zwarte Cross in the Netherlands, which was by then the largest festival around. And if you... I'll do it like this. Yeah. So this is the less boring lawyer pick of me. I'm an attorney at law, which is basically a little bit different than from a lawyer. Like an attorney at law is registered, so it's a protected title, and there's all kind of legislation and rules I need to abide to. I am specialized in intellectual property law, basically copyright, neighboring rights, trademarks, trade names, etc. Media law means if you had a really great night, but you're on YouTube next day and you don't want to. And contracts. Contracts, I'll get into that a little bit deeper, but it's basically the way we arrange stuff with each other. It doesn't have to be on paper. If it's on paper, I call it a contract. I call it an agreement if it's not on paper. It's like a little bit broader. Furthermore, I founded the legal collective Backstage Legal in 2020. We are together with 5 partners and Danny, our intern. And all partners are coming from the creative industry themselves, meaning we have a rock star that made the music for Suits and Californication and still in a band. We have a comedian that's also a rapper and a radio host and an attorney. Our newest partner is a model and an actress. She's currently living on Bali and working from there, which is quite interesting, of course. And we have a partner that owns an event production company in Amsterdam. And as I said, I used to double as a promoter. I don't do that anymore because it's too much stress for me now, and difficult to combine with running the full practice and a company beside it. But as said, I'm still DJing, not as much as I want to, but slowly picking up the pace again. And did a really cool gig last Friday during ADE at the Tropical Institute. I am also a member of the appeal committee of the Dutch Performing Arts Fund. And that is the committee that gives advice if some funds were rejected and people went into appeal. As you can imagine, currently with all the changes in the Dutch government and the connection and results and consequences in regard of giving money away are huge because the current government doesn't really see art as something important, or at least something that money should go to. So I want to cover a couple of topics with you today. Basically, the first thing is, why should you know anything about the law? I think it's a very important question, and if you realize why you should know this, it's important. You realize why you should listen and learn. The second thing is, what are music rights? So what does the law say about music rights? And third, how do music rights apply to AI? Why is the latter important? If you don't know what music rights are and how they work, you don't know how to apply them to artificial intelligence in the creation of music. So if I would be only talking about AI, it would be very much into detail, and you would need a lot of prior knowledge. So the first part is basically, why should you know? Second is, what are music rights? And the third is, how do music rights apply to AI? There is a Q&A afterwards, but if there is something you think like, I need to ask this right now because this is happening in my current practice, please just raise your hand and stand up, introduce yourself, and ask your question. Okay. I think knowing something about the law and knowing something about music rights is important. As said, music rights are part of the music business. There is an article in the law that says that you need to arrange an assignment of rights or an exclusive license in a contract, being like an agreement being signed. And if you know what your rights are, you can make smarter deals. I think a lot of people signed away their rights not knowing what they were doing. And in the end, for example, maybe if you have heard of the rapper Ronnie Flex, maybe you've heard of the DJ, he won again, Martin Garrix. They signed contracts that were not particularly in their benefit. If they would know more about their rights, they could have made smarter deals. Like smarter deals usually lead to less risk, more income. Less risk, more income leads to more freedom. More freedom leads to more creativity. More creativity leads to better work, more fun, etc., etc. And you won't get screwed over. That's nice too. Or at least within boundaries. So as said before, a contract is a way, sometimes a necessity because of the law, but it is also sometimes a way for a company to limit their risk and maximize their profit. Meaning that you either do it as a necessity because you need to do it because of the law, or you try to deviate from the law. If you are deviating from the law, you better be aware of what you are deviating from, because otherwise you think it might be normal, for example, to have super strict audit clauses that cost thousands of euros. And you will need to follow those if you want to see anything about the books from a publisher, a record label, a booking company, etc. Well, it might be just in the law that you have a right to it. So I think if you know more about rights, you can make smarter deals. We'll dive into copyright. What is copyright? And it's at least in the Netherlands and in the EU, it's a pretty old school law. I think ours is from 1912, and it contains a lot of difficult old language. I kind of broke it down for you here. And what is really important also later on, if you look at the AI part, is what it is. So copyright, mind you, is an exclusive right. Just keep that in mind. If you have a copyright, it is exclusive regarding a work of the maker. So either by you or your successors, you can transfer it or die. I prefer transfer. To publicly perform, that's one. And second, to reproduce the work. So then there's a whole section in the copyright law that says what is reproduction. So keep those terms into consideration. Performance, basically uploading it, letting hear, playing it on stage. And reproduction means to record it, means to edit it, and means to copy it. Could be like physical copies, could be digital copies. And together, performance and reproduction are called exploitation. There's a whole law about that as well, but keep in mind the bold words. They are super important. And then there are moral rights. They're also called personality rights. And the most important ones are that you can object to an unwanted change of your work or to mutilation, for example, but also to object to the disclosure of your work without your name as a maker or without the right name, or etc., etc. So it is not so much about the right to have your name credited. It is currently still the right to object to a situation where your name is not credited. Do you get the difference? Good. So it needs action. The next question is how to fill in that obligation, and we'll get to that a bit later on. And I'd like to have a discussion with you. So how would this be practical to do this on a very large scale? So keep that question in mind. Then the second thing is neighboring rights. There has been a lot of litigating about neighboring rights recently. I already mentioned the Martin Garrix case. I already mentioned the case about Ronnie Flex. Neighboring rights are the exclusive rights for A, a performing artist, and B, a recording person or company. You can, as an artist, have the exclusive right to record your performance and then exploit it meaning selling, renting, lending, delivering, performing, displaying, etc. So there's still that public performance function, and also a copy function, because it says also a reproduction thereof, or to import it, etc., which is a little bit less relevant now. But they're quite similar to your copyright. So the copyright is basically for the author, publisher on text and a work, and this is about a performance. Then there are the neighboring rights for phonogram producers. You might notice, you think like, hey, I'm a producer. There's a lot of mix-up about using the right words in the music industry. A producer, as used in the terminology of the music industry, could be a lot of things. Could be that you're the writer, could be that you're the performing artist because you play it on your keyboard or you play it live or whatever, and that you are the person that is actually responsible and took the initiative for the first recording. So I'm trying to make it practical, but keep in mind that the legalese in this regard is key. If you go to a court, the court will look at still working. Thank you. The court will look at this and not so much how the word on the street is, not so much how your contract is. They basically test it to the law, and that's why I think it's important for you to know. It is about the first recording of sound, and you will have a right for a reasonable reimbursement. So it's a little bit different than copyright, which is an exclusive right, and you can actually stop somebody from doing it right away. Here it is, you can stop somebody if they don't give you a reasonable reimbursement. So to put that into practice, a phonogram is a recording of sounds. So it's not a recording of sound and video, it's just a recording of sound. It should also be the first recording and kind of ready to start exploiting it later. Exploiting was public performance and reproduction. And the phonogram producer, as mentioned in the law, is the person or entity that records a performance on a phonogram for the first time. Now, what does that mean in regard of case law? So you need to look at the rationale behind the law, actually, which is to have a return on investment for the people that actually, back in the days, bought, owned, or rented the studio. One sec. Old school studios, and also in pop, in jazz, and in rock, are usually quite large and very expensive, either to purchase all the different equipment or instruments. But it's really different from people making hip-hop music, which is nowadays almost entirely electronic as well, or dance music, because you can do that behind your laptop. Yes, you had a question. No, they are equal. There's no right that is more important than the other. And for example, if you are doing a synchronization, maybe you've heard of it. Synchronization basically means that you combine a copyrighted work with music and images. It's like a triangle of copyright, neighboring rights, and images. For commercials, for movies, so for each commercial that you see, the company that orchestrated the commercial or is broadcasting it will need permission from the copyright holders in regard of the usage of the work, but also from the neighboring rights holders for the performance and for the recording. And then, of course, for the creators that made the images. So they coexist. A little bit back to the case law. So the rationale is to have a return on investment for the person or entity that took the initiative for the recording. These cases were about the Dutch Neighboring Rights Act, but the Dutch Neighboring Rights Act, I think same as basically all the other laws, they derive from treaties. They derive from all kind of regulations from the EU, or sometimes even worldwide. What was interesting here is that in the Garrix case, the court really nicely put together what are the different requirements to become that phonogram producer. And they went all up into the Supreme Court, and somewhere along the way, some professor said, well, it is about the financial responsibility, but that could be a little bit broader. It could also be technical, it could be organizational, it could be creative, etc. Now, why is this important? If you do not know when you are the master owner, you do not know when you have a certain set of rights. And if it's just in the contract that, for example, the record label is seen standardly as the phonogram producer, then you're giving away your rights basically for free because you don't know that they are yours. That's one. Second, and that's a little bit technical here, but it underlines the importance. In both the Garrix and the Ronnie Flex cases, the artists were unhappy with their record label. So what they did is they wanted to dissolve the contracts, and a consequence of dissolvement is that the transferred rights need to go back to the artist. Get it? So basically, if I sell you my phone, you don't pay me, then I get my phone back, right? Same goes with what they did in the court case. If it was yours and if you assigned it to somebody else, you dissolve the contract, then it would revert to you. But what if it was never yours? Then there is nothing to revert. You can imagine it in case of Martin Garrix and Ronnie Flex, this was about hundreds of thousands, if not millions of euros. So that's why it is really important to be aware of your rights. If you do not know what your rights are, and you have to find a way along, I think, like 7 years of litigating, instead of during a negotiation, then you kind of lose out a lot of money, 50% of the Sena income, etc., etc. And of course, you can make agreements about it, but this is how it works, and this is why it is important. I've set it all up in a schedule. If you next time fold the paper and look at what rights do I have as a creator? Is it in regard of the work? Did I write it? Am I the composer of it? Regardless of how you call it in your practice. But this is what it comes down to. If you talk about works, if you talk about copyright, you need to talk about publishers. You don't necessarily need one, but it could help. And you're talking about Buma and Stemra. So this kind of connects to my earlier remark about how should we maybe on a large scale let know that we don't want something going on with our personality or moral rights, but it will also connect to an an opt-out for AI. So keep in mind, we'll get to that later. Buma in the Netherlands is the party that on a large scale collectively collects money for public performance. So what happens if you go to a club, the club needs a license from Buma and Sena, they pay money, the money goes to the artist, at least that's the idea of it, and Buma and Sena grant permission for the public performance of your work, your performance and your work, and Sena does that for your performance and your recording. So on the right-hand side, we have performing artists, phonogram producers, and that is a set about the phonogram, aka the master, record labels, distributors, Sena and Norma. Norma is a little bit less important. That's basically relevant when you have a show on TV or a live registration. Okay. Enough with the boring talk. Commercials first. I don't have YouTube Premium. And I don't have any stocks in Videoland either. Neither do I have stocks in this one. I do need a little bit of extra sound though in a bit. Yes. Let's try this again. It's really better with sound. Nope. So it is the click thing that it didn't make. Nevertheless, I'll. You have a different cable? Yes. Well, yeah, it's supposed to work. Nevertheless, I'll just talk you through it without our big Rotterdam friend Reinier Zonneveld is doing his works. Um, Maybe this gives us an opportunity to actually discuss what he's doing. So you just saw his computer screen, right, with all the different colored items on it. You see some of his gear with a keyboard, a 909, his drum pad, basically. So maybe this is a trivia question. If you, that's definitely not Reinier Zonneveld. If you look at what he's doing, how would you, if you could give him any rights, which rights would you give to him? Anybody has an idea? Yes. Although you could discuss it, of course, because you could ask whose initiative and responsibility is it to make this recording? Is it a state of trance where he was invited and maybe paid? Or is it Rainier himself? He said, I wanted to do a set here. Can I do it in your studio? Um, and maybe it's important who owns the studio. But I like the idea, and you get where we're going. He is, at this point, I think, indeed responsible for making this recording. So being responsible does not mean that you have a nice promotion vehicle or that you're basically doing it out of like making artwork, making videos, putting it online, launching ads, etc. It is really about the creation of the first recording of sound, not about all the other stuff around it. Maybe I'm gonna pause this here. Doesn't work. Well, does anybody else have an idea? Yes, correct. Also the performance, because he is indeed. Um, Works right. Well, we'll just leave the sound part here. I don't really know how to fix this currently. It's probably my bad. Um, but yeah, indeed. Okay, that's a good moment to skip. Yes. So, in regard of the performance part, he is indeed like playing live, but he has another right. Any of you know? Yes, he is live making his compositions. So on his laptop, you could see all the different kind of compositions that he had. And I know that he's a lot of times working with some preset compositions, or at least snippets or stems or samples. But well, if he's doing his famous 10-hour gigs, it changes. So from one performance, he's now doing it live, but from one performance, you see him actually on the spot creating a composition, changing it. So it could be that he is also making a remix of a track of somebody else. You also get copyright for that if you have, well, you get copyright, but you need permission. Second, he is indeed performing artist, and he could also be the phonogram producer. This is what happens, of course, a lot if you look at electronic music production in hip hop, but especially in dance music. But it's the easy and nice example of where it kind of comes together. Having that said,
AI. When new content is created by artificial intelligence, it's called generative
without the
AI.
cable, it works.
This could involve generating texts and images, as well as videos, music, or voices. To do this, you describe in a chat dialog box what you want the AI to create. This description is called a prompt. The generative AI tools provide answers to all sorts of questions, summarize complex information, and generate diverse ideas quickly. Depending on how they're used, they can create short stories, paintings, pieces of code, or even musical compositions. The foundation for this creation lies in large amounts of data that the AI system accesses to identify patterns and similarities. The content produced by the AI is new. It's often impressive and challenging to distinguish from things humans have made. Generative AI can also be misused. In so-called deepfakes, AI is utilized to produce images or videos that seem real. AI-generated texts are also tough to recognize as machine-made. Moreover, the AI can provide answers that sound correct but are actually incorrect. This is called hallucinating. The quality of what's created depends on both the quality of the data used and the quality of the prompts given. To effectively utilize generative AI, we need to learn how to guide the tools with meaningful prompts and use them thoughtfully. Generative AI holds immense potential and can help us in many ways, such as serving as a writing or learning partner. However, the AI should do the hard work, and humans should be responsible for the facts.
That was just a quick recap so everybody is on the same page about generative AI. There are quite some legal issues with it. Again, it is really important to acknowledge and to know what type of rights are relevant for you as a maker, meaning copyright, neighboring rights. Copyright is to the person or entity that created the work. A work basically needs to be creative. We'll dive into, and I'd love to hear your opinion about that, what creativity is. We'll dive into that in a bit. A publisher doesn't have an own right, such as a record label or a phonogram producer might have on the neighboring right side. So the neighboring right side for the performing artist and the phonogram producer. What you could do with your rights was performance, reproduction. Performance meaning putting it online. Reproduction meaning either fixating it on a carrier, like putting it on a CD, etc. Changing it. And third one, so copying, changing, distributing. Then we look at AI, because what is going on there? What is happening if you use music into Suno or Udio or all kind of different AI apps that work with music? So the question, if you look at, there are like three main subjects. Basically, the first one is on the input side, then there's the processing side, and then there's the output side. If you look at the input side, so what goes into the big bad machine? So how is the music used, and are there any differences between countries? To make it super complex, yes, there are. In some countries, they basically put out the red carpet and said, come to us, you can do anything here, because we want to stimulate creativity, innovation, etc., etc. And other countries are more leaning towards the protection side. And on the output side, we get to the questions, what comes out? Is it protected? Who owns it? Is it licensed, for example, already directly to the platform, and can they use it again in their training data? And does it create any infringement? So what comes out, does it infringe on a work that is already there? To show you how complex it is, I tried to set out how it actually works if we are talking about harvesting data from the internet to put it into all kind of networks, to put it into large language models. I'm not gonna dive into all the different type of networks, but it basically boils down to this. So when they scrape music and they try to create a database that the AI can work with, the question is with what goal? So this thing doesn't work except for this. So is it just to create a data set for training? Is it actually creating an AI model, or is it generating new output? And when it's training an AI model, is there a reproduction? You remember reproduction was one of the exclusive rights, right? So if no, then the chance for a violation of rights, if the works are obtained legally, is not so big. But when we are talking about making reproductions for an AI model based on your work, then there is a bigger chance for violation of rights. It makes it worse if the reproduction is not temporary. So there are some AI models that actually do reproduce your work, but they do it temporary and they delete it after a while, but some don't. Then if it's not temporary, is there an automatic removal or permanent storage? You can of course understand that if there's a permanent storage, there's a bigger chance for violation of rights. So if we're looking at some requirements for the text and data mining exception, which is an exception to the exclusivity of your copyright, you need to answer the question, did we have legit answer to works? If no, violation for rights. If yes, you come in this group, this schedule. Copies are only stored as long as necessary. No, you need permission. If there's no permission, bigger chance for violation of rights. And this was the part I was speaking about earlier. So you could opt out for having your work used in training data and in large language models. But how? It needs to be some kind of effective, machine readable stuff. And that is maybe quite easy if you look at written works, because you can have the copyright sign, which you don't necessarily need, but becomes of more importance right now. You can put it like in your website. It's easy. You can just build something into your website. So the crawlers can see, we don't want it. We don't want our work to be copied and to be used into a large language model or an AI model. But what are your thoughts on this? How are we going to opt out on music? Any ideas? Yes. So you mean in the file, like hard coding it, or? Yeah. Yes, that would be. I don't know if it's technically possible currently, but yeah, indeed. If you register works, you have on the work side the ISWC code, and on the recording side you have the ISRC code. Yes, it would be really nice if it was connected to that. Relating to that, who gives out those codes? In the Netherlands, for example, you can go to SENA, the public performance organization on the neighboring right side. They can help, and I think that is the direction we might need to go to. That the role of our public performance organizations should do something with this. I don't know the technical answer because it could be indeed hard coding it. It could be a disclaimer. But ideally, everybody that uploads music via a distributor or Spotify, Apple Music, etc., has a clear opt-out of if you want the AI models to use your works, your performances, and your recordings to learn from, right? Any other ideas? How should we do this? Yes.
Wait a minute.
I yeah, I believe there are ways to kind of make your record unrecognizable by AI. So basically, to AI, it's some sort of noise, while we hear it as a normal recording. Maybe we could use something like that.
Yeah, that would be a good solution. It's basically what we had back in the days with digital rights protection and management with CDs and DVDs, and maybe if some of you ever rented a tape that you could in the beginning see like a notice from Brein, or that you couldn't just copy it. I think MP3s had that for a while as well. Blockchain could be an option maybe, so that you instantly release it with a data set, and via that way you can see whether it's used again. But we don't have the solution yet. That is partly because it's so immensely difficult to know what happens inside an AI model, and how we should see this working all around the world, taking into consideration that, for example, in the US, they really look at intellectual property laws different than we do here. Then there's, of course, China, where they have a really also a different approach. To give you an idea here, and I like that about our law, intellectual property is really to protect that connection between you and your work. So from a philosophical point of view, it's like a nature philosophical way of looking at rights and creations and creativity and how to stimulate that. If you look at the US, it's basically commercial. You wouldn't have guessed, right? It is a commercial right. In China, they see it really as a right to copy and to use it again in progressing how the entire system and society works. But of course, there's the internet, and the internet is crossing borders. So how and what applies when, that is still something that people are really fighting a lot about. And this was just to illustrate on how complex it is. Of course, if you look at the input side, it is important that you need to know who owns the rights to a work, a performance, and a recording. So we just had that part about copyright a little while ago. Second question is there an opt-out and can you read it? The third thing is fair use. Who has heard of fair use before? Some people? Yeah, we don't do fair use here. So fair use is something they thought up in the US, and that is about transformative use of a work. You can think about mashups, remixes, bootlegs, etc. And it's especially relevant if you look at the sampling scene, where they use a lot of different samples in music to create something new. If you do it at home or just to boost your own creativity or to learn, then it is something relevant, and it could be a relevant exception to the exclusivity that you would normally have as a maker or creator. It doesn't apply if you start commercially exploiting your work, and if it's bad for the original maker. So if they lose business opportunities because of your fair use, then it doesn't work. And of course, on the input side, the territorial aspects of where the AI engine is and where the action, maybe the upload or the possibility to download, or maybe even where their servers are. So that makes it quite complex currently to answer how does AI apply to music? Only on the input side. Then on the output side. No, wait, maybe I want to stick with the input side for a little bit longer and have your idea on what do you think should be the balance between protecting the exclusive rights of creators, and the possibility for innovation for AI, because you are having this AI week. Some of you have encountered how it can work in your benefit. Other, maybe as a creator, are a little bit afraid of how it is negatively affecting your practice as a musician. So what do you think? Just some opinions around. Yes, in the front.
Yep, yep, yep. Thanks, Jan. Like as long as you don't give your name out there, this is the voice of Billie Eilish, for example, and like if you don't give permission to like let your voice being used, then I think it's strafbaar. Hoe zeg je dat in het Engels? Strafbaar.
Yeah.
Yeah.
Punishable. Yeah.
Punishable. Yeah.
Yeah, but should you give the permission, or should you actively say that it's not allowed? So should every artist say it's not allowed, or should you be protected? It's an open question. Should you be protected from the moment on that you are actually just being out there?
I think like if there are some artists already out there who let their voice being trained to be a new AI voice.
Yeah.
So like I think if someone is okay with that, then that's fine. But like yeah, if you are like an artist, I think that artists who are out there who don't think that is right, they should be protected.
Yeah. Yeah, I mean, you might have heard about the Grimes case. I don't know if you were referring to that.
No.
Okay, so what Grimes did, she's an artist, and what she did is basically say, you can all use my voice. Go ahead. That was really smart. Why? She let others use her voice. She said, you can use it if you give me half of your royalties. That's nice. Why? Because if there is an infringement of rights and you want money out of it, which all US artists and lawyers, etc., do, you need to prove what your damages are. What she did is, instead of waiting for this to happen, she took a flight forward and said, well, I generate this much money with people using my voice in AI, and they have to pay me half of their royalties, so this is my damage amount. So she could prove that her voice actually has a financial value in the use of AI. That was pretty smart. Of course, it also boosts her relevance, etc., etc. But if you boil it down to why people litigate about it and what's going on with this, I think she made a very clever move with saying, yes, you can use my voice, but you have to pay for it. Which connects to the neighboring rights. They're a little bit different in the US, but the neighboring rights, so they're not specifically like working with copyright that you have an exclusivity and can stop all use. You have an exclusivity if there is no reasonable reimbursement paid. So that's a nice way how this happens into practice. And do you think that people should be able to use your work in AI engines to train off? Yes, there's a question here. First, you were already waiting a little bit.
Yeah, I was thinking about the previous question, how it would go like right wise, and if you think it should be able, you should, the AI should be able to use your music as a way to improve. And it kind of makes me think of the last time we had things like this with downloading music when that first became a thing, and the music industry kind of plummeted because everyone downloaded all the music for free because it was online. Um, I feel like it's a bit of the same thing maybe with AI, that there just needs to uh, it just needs to rise of a platform where artists can sign up, like the Spotify, the streaming, the Apple Music, the iTunes, all the streaming services that then gave a bit of power back to the artists and the music industry. I feel like there might be a similar thing for AI in the future that works so that artists still have income when their work is used for improving AI, instead of all the yeah kind of illegal, kind of weird, unseen downloads right now from all the music over the world?
Yeah, because it's usually not with an explicit permission, and it's also usually not with a reasonable reimbursement. So yeah, licensing could be a solution, and I think Buma and Sena or their foreign counterparts could play a detrimental role in this, of course, because now everything just happens, and I think that is with most innovations, Napster, etc., streaming, everything was just online. Same with TikTok, actually. TikTok never had a license for a long time. That's why Universal pulled all their music. Um, it happened, it was important, people could go viral, but nothing was paid. Same goes with AI, but then we have to ask ourselves for what use are we collecting money? Are we actually, is there some form of performance? I don't know. It is usage though, but there's definitely, or at least in some cases, copying going on. And I think, yes, we need to value that, especially as the AI companies are generating a lot of income and being sold for millions and millions and billions. That it's reasonable that their product or their service pays something back to the creators. Yeah. But what amount and how we should do this, I don't know. Yeah.
Yeah. Is there not only like a problem once there's like output that's being commercialized by the AI? Because if you just input and the AI is just trained, there's no problem, right? Or
Yeah, well, output is one thing, but if we stick to the input side, it depends a little bit. What actions are being taken by the AI company? So, in what way is the input used, and is that connected to uh, an exclusive right for the maker of a work or the performing artist on a performance or recording? But yeah, I agree. If it kind of like stays inside, then it's a little bit less relevant. But if it stays inside, then you never know about the outputs, and then it's just about the process and the learning. And I agree. If you look at the schedule that I showed you earlier, um, then you're not taking away any exploitation possibilities, perhaps. But that would be, yeah, a little bit ethical. And you see the first ethic AI engines already popping up saying, yeah, we train on music that was specifically written for the AI engine, which is a crazy idea if you think about it, right? Because people are actually making music for an AI engine to work to make music. Yes.
so let's say in the future there will be laws that kind of limit the use of AI training on like copyrighted music and stuff. Right now they are performing on copyrighted stuff, I presume.
Yes.
So
Yeah, Udio just acknowledged that. And
yeah.
yeah.
So all the music that's being created now is created like based on all those copyright music. Is there any way there can be like legal consequences for music that is being produced with those masters right now before there are any laws in store, or will there not be any legal grounds to like prosecute people who operate on that basis now?
it's a good question. It's a little bit layered, so I'll try to dissect it. It's not the case that there are currently no laws. The current laws are the current laws, and we just need to apply them to AI. So I think as long as there are no exceptions and if there is no litigation about it in the EU, especially in regard of music, then it will be very difficult to kind of know how we should apply it. So there are currently about 30 cases pending in the US. We did have one German case and one case in Czech. The German case was basically about if if you have a lot of prompts, like 700 prompts into a work, if something like that can be copyright protected. And the case in Prague was kind of similar if the result of all those prompts can be protected. But most stuff plays out in the US. So we can look at it and think about how we should apply it and if it's correct, but we don't know exactly how we should do it in the music industry currently. But that doesn't mean that there are no laws here. The second thing, yeah, it will be very hard to find a way to keep that output and and input side and processing side separated, because it's also a little bit of a black box. You don't know what's happening inside the AI model if there is no transparency on the input side, in the processing side, and the output side. And I think the new laws, like the AI Act, are making that concrete. But before that AI Act is also put into our national legislation, and before it's been put into national legislation that is also tested in court, yeah, we're talking about years. And that is the difficult thing with laws, is before they are there, the development's already gone. So it's either a diabolical choice between creating new laws for the future or applying our old laws to the future. And that is what everybody is currently doing, and trying to find a way, instead of only talking about the status quo. Like, the status quo is we don't know. But we need to find, and that's why I like to discuss with you, what is reasonable? What is your creativity worth? What do you see as creativity or protection? Because those questions are the underlying questions, whether, like, if you look at the input side, if you don't have a right to work, then of course, then there's no real problem, right? But so what is creativity, and when do you get those rights? Well, on the neighboring right side, that's not too difficult actually, but on the copyright side, that is the basis of our creativity. When is something creative? Isn't creativity making an interpretation, a reaction, and copying existing building blocks into a new work? Or is it something more at the core that you don't know or can't explain? That's also a difference between how you actually create something. Because if you think about it, if I don't produce myself, but if I'm DJing, I want to go somewhere because there's an image in my head, and I try to create a soundtrack to actually get there. So at that point of time, it's something, either a reaction to something. It is something that is stored in my mind. It is something that I try to mix up with all kind of different scenes that I've been into, different feelings on a dance floor. But can I say that it's mine at that moment? I don't know, because it's also based on other things. For that intermezzo, just what do you see as creativity and copyright? Yes.
Yeah, copyright. I had like one more question, because like if you start thinking about it, like if you write a song uh, as an artist, and there is copyright, of course, like you can't copy a melody like the whole melody, but you can copy like a bit of the melody until a certain amount of seconds.
No,
Oh.
that's a myth.
Oh, so some people say that.
Yes. Those people were not lawyers.
Probably.
So if you want to have protection on copyright here, it is about if your work is original, created by human. This is already different in the UK, where there is also protection for computer created works. So a work could be protected here, not in the UK. Sorry, other way around. This goes for copyright, but also for samples used on the neighboring right side. Maybe you remember or know the band Kraftwerk. In the 70s, they were kind of the pioneers within electronic music. They went all up to the EU Supreme Court, and the EU Supreme Court said, if a sample is used and you can recognize the sample, it is a copy of the original recording, aka the master. That snippet, I think it was 2 seconds long, from their original track, Metaal auf Metaal. If you look at the copyright side, it just needs to be creative, basically said, to be protected. And yes, I agree that something that is 1 second long might be very difficult to be creative. So if it's just one note, I don't know. If it's a combination of notes, yeah, it could be. But on the other hand, there's a limited amount of different variations in compositions, tones, schemes, etc. Which raises the question, they actually did this with an AI model. They made all combinations and put it online and say, well, now nothing is new anymore. What do you think of that? So can you be creative if everything is already out there? And it is said, well, when they did this, it was actually a professor of law. It was not somebody who was just in its mom's basement putting out stuff. This was an actual research. They put everything, all the combinations you can musically make outside. They put it on the internet. And from that point on, they say there cannot be any plagiarism. There cannot be any copyright infringement because it's all out there. To go back to your question or remark, copying of a snippet can be infringement on the neighboring right side as well as on the copyright side, as long as what is copied on the copyright side was creative enough. Also for AI, yes. Which leads us to the output side. So what comes out of the AI engine? Is that copyright infringement? That depends a little bit. So some creative agencies, they say, we want something like the sound in their last Nike commercial, but not being the exact same commercial, but we want the same vibe. Then you're going to look how close is that vibe to the original work, to the original performance, and to the original phonogram. With AI, you never know. If you look at the general terms of service of those platforms, they don't know. They will not give any guarantees. And if you use AI in the creation of work, you need to be very well aware that what you put out there might be infringing on somebody else's work because the AI model was trained on somebody else's work without permission. So if you just create something with Udio or Suno and put it out there, chances are quite big that you're actually infringing upon somebody else's rights because it looks too much, for example. There are some examples of AI engines where a prompt was given to make a song text about a guy leaving his girlfriend, etc., etc., and the text was exactly the same or 99% the same as the original song. So you think sometimes that AI is doing something creative. Well, in some cases, they're just copying it because it's the most logical form, logical word, logical letter to follow after the other if it's a very famous song. The second thing is, so copyright infringement, neighboring rights infringement. Neighboring rights infringement could be if a performance of a certain artist is so unique and you copy it that it's looking too much alike, which also closely relates to plagiarism. Plagiarism is copyright infringement, but also happens if something is not copyright protected. It's basically if you are doing some or posing that you made something while you didn't. So this is very relevant with sampling and remixes, for example. So if you use a sample from somebody else and you do not say, hey, the other person made it, and you act like you made it, then that's plagiarism. That's what all the Ed Sheeran and Madonna, etc. cases are about, that they used a different part of one of their protected songs and used it into their own new work. Then there's the question, can you copy a style? Because style is usually not copyright protected. In the EU, could be different in the US. How about stealing a voice? We touched on that. How about personality rights? How about passing off as a voice that really looks like Elvis? And then Elvis is dead. It depends also how long he is dead, but you can understand that it can be different from a current very popular artist where you can have the lyrics of Madonna sung by Kanye West, for example. I'm not sure if that's a good choice at this moment, but you know, you could do it. what kind of rights do they have? And what kind of responsibility do you have if you use AI in the process of creating your works? Then there's, of course, privacy and fair use. And the last question, what comes out of AI? Is it protected? What are your opinions on that? Yes.
Yeah, cool.
So let's say you get AI just in Suno, you put a prompt, make a song. If you approach it like sampling with rights, you'd have to credit every musician the model has been trained on. That's not really feasible, I think. So would you, I think it's fair to make an argument that output from a big music making AI should be in the public domain and not clearly it can't be owned by the AI company because the data isn't theirs at the moment. If it is, it's a different story, I think. But how it's set up now, I think all the output should be in the public domain.
I understand where you're going, yes. The current cases where people wanted to file for copyright protection in the US, they have put around 660 something prompts before they could create the work. How is this different from Rembrandt or Picasso being in their workshops telling their students, because they didn't paint everything themselves, what to do? Because everybody kind of thinks the copyright is from Rembrandt. Doesn't that work the same a little bit? Giving an instruction, like 660, that is very precise. So if I'm a photographer and I want to use a diaphragma that is smaller or bigger or a different angle or different lighting, what I'm doing is just like switching it, right? If I'm doing it manually or I'm choosing a different composition. So from a frog perspective, how is that different with telling somebody else or telling a computer what you want to do? Because what you have in your head, you're just making it verbal and an instruction instead of keeping it internally and just doing it. Could be that you think, well, that might be the same. But on the other hand, indeed, maybe not. Any other thoughts about this? It is difficult. I acknowledge that. So there are still a lot of things we need to touch base on with each other.
There's still one question over there.
Yes.
Um, I don't know if you know how this works or if anybody knows how this works, but when AI creates a song, anything, I like are the instruments, the sounds that you hear, are they like little snippets from something, or does it somehow create the sound itself? Because of course, if it's like the guitar from this song and then the chords from that song, then it's kind of like copying works. But if it's somehow creating its own guitar, then it's creating technically sort of an original work.
Well, original work, if you look at the copyright side, needs to pass the bar of creativity. On the performing rights side, or the neighboring rights side, it could be that, well, it could be a very relevant question: who's actually performing? And if you look at the phonogram side, yeah, who's taking the initiative and the responsibility for the recording? That's a good question, actually. And to be clear, I don't know the current answer, but I can only put it against the current laws. So it needs to be creative to be protected. But who and who's doing what, and what does the AI engine do in regard of the use of sounds? It could be that they're feeding off current samples and or stems even, and making it really small. And on the other hand, maybe they're just working as a computer program like Ableton or Cubase or Logic, and using it in that way, made out of their standard little compartments, how they can create music online. But that's a good question. I don't know. This is something that happens in the black box of music. Yeah.
Can I add something to that? Because
Yeah.
isn't it like if you go in Logic and you just buy a plugin and some of you just steal it? Be my guest. But if is it because we sort of know how Logic works? If you want to expand, you just buy a plugin, and then you pay for the one who makes it.
Yeah.
And then you use his or her creativity. Is it not that shouldn't we not know more about this, how it works, and shouldn't that be in a law?
Yeah, this is what they try to arrange with the AI Act, to create transparency about AI. How is it used? Is the output created with AI? We're still looking into a way that we can use that as proof. I think transparency and clarity are very important in this. But I always say, if a new client comes in, I say, if you don't have any proof, you probably don't have any case. If you can't prove what happened, then it will be very difficult to reach the end goal and tell a judge, like, hey, these are my rights, this is the chain of title, this happened then, and you can see that the new work is, for example, created by AI. So that is, I think, one of the next challenges of the music industry in regard of rights. How do you know if AI is used, whether on the input or on the output side? Because there's currently, as far as I know, nothing like a real clear answer or solution that we can check it. There is no filter how we can see if it's AI made or not. But yes, should happen.
And using your knowledge as a lawyer, could you give a sort of view of where you think it's going to in that manner? So what do you expect on that?
I expect that the transparency thing, of course, will come up. And hopefully we will go back to making databases talk with each other. So that's a little bit of a sidestep, but metadata is a huge problem in the music industry. Metadata is basically who owns what in a certain song or recording. If the metadata is not correct, you don't know who to pay, you don't know who to ask permission. If the metadata is not correct and you don't have databases on the work end side and the recording end side that can communicate, so if one song is being played on Spotify, that they know who are the copyright owners, who are the neighboring rights owners, then it will be also very difficult to connect that data to AI models. If you have communicating databases, and I think that is what they're currently working on pretty hard, if you have communicating databases, you can track down the use. If you can track down the use, then you can make agreements about it, or you can see where like money is being left out or that it's not being paid for, and you can give a licensing structure or an opt-out structure. But there needs to be a certain form where we can track it. Solution might be blockchain, solution might be something else. But a blockchain system where everybody knows how certain assets are moving or changes are moving all through the chain, yeah, might be a solution if somebody wants to take something off or add something to a chain, or who are the rights owners. That could be a solution for this.
Okay, cool. I must say, I think we need to sort of round up at 2 o'clock because a lot of people have to do some work before our final final countdown is over there. So if I don't I don't want to ruin your workshop, but do you have anything you would say? I really want to mention this before the final question round.
No, this was my last slide before my battery cut out.
Okay.
Because it didn't really work via that way. But no, next was the question slide. So just a quick recap. So we talked about Why is it important to know what your rights are? So if you don't know what your rights are, you cannot make smart deals because you're not aware of what you're giving away or how it's being used. Second, when are your creative outbursts protected? If you look at the copyright side, it's basically about composition, work. If it's creative enough, those rights can be published or can go directly to a public performance organization such as Buma and Stemra. You have an exclusive right to upload it and to copy it. And copying or reproduction can also mean fixation, copying, and editing. On the neighboring right side, your performance is being protected. It doesn't really have to be super creative, but it is almost instantly protected. And on the phonogram, aka master right side, the person or entity that took the initiative and carried the responsibility, not only financial, it can be broader than that, for the creation of the recording, meaning the first recording of sounds on a carrier that is fit for commercial exploitation, that party is initially the master owner. Then we went on to AI. We had the input problems. We had uh, um, the problems, what happens in the black box, and the problems that we have on output. So can AI use your work? It depends. We don't know what's happening inside. And third, be very aware with the output as you could be infringing upon the rights of others. That was basically a quick recap of what I've been telling, and floor is yours if you do not have any additional questions.
Is there any last question? Yeah, I'll come to you. And Mila as well, and that will be the last one.
I was wondering because you earlier you mentioned that laws take like 2 years to form, and then the or more, and then the progress already happened, and it's kind of irrelevant maybe. If we know that the technology is now improving so that in a few years we can probably detect where AI gets its data from, can we already make laws that apply to when that technology is here? Is that something that happens?
What they do with laws is they try to draft them in a way that they're open and ready for the future. But a court or the lawmaker cannot foresee all things that will happen in the future. So I really recall our Court of Appeals in the Martin Garrix case saying, we don't know how this works in dance music industry. And I was like, you can ask, but so they kind of acknowledge like this is new to us. This is new to us how we should see the phonogram producer side, because in that case it worked about making remixes and going through the editing studios, and then we were talking about did the sound change, whether it was a remix or not, etc. But it was for them very difficult to apply the law, although it's draft and open. I think this is something so new that they don't have the answer. So drafting a law that is tackling this issue doesn't say that there are new issues coming in the future. So we need to keep it open. And I think the core and the rationale behind the law is something that we need to discuss with each other. You cannot foresee all kind of ways that how people are going to infringe your rights, but you can talk about why is something protected. What do we see as creativity? How should creativity sometimes collide with innovation? I think that is the discussion we need to have, and hopefully, and they are doing this, but hopefully these kind of things contribute by hearing it from makers, so that our Supreme Court in a few years doesn't have to say, well, we don't know how we need to treat this with the Codarts students, right? You need to have an open discussion and look into the future and be open that sometimes protection is like right on the battlefield at the other side of innovation.
If I have one tiny question, one bigger question and one tiny easy question. But the bigger question, kind of about law in general. You said that the copyrights and neighboring rights, they're like kind of equal to each other. If two parties with those different rights have a disagreement, how is that solved if neither has a final say?
They hire me.
Okay.
Yeah, how is it solved? Usually with deal making. So the industry is yes about creation and B about money and about ethics, but also and about feelings. Sometimes feelings get mixed up with money and ethics. You try to find a solution, and if the solution cannot be found, you go to a court or you go to a judge. Ideally, before that, even more ideal, you make agreements before this happens. But yeah, if good example, just I'll give a quick answer with Taylor Swift. What happened? So she re-recorded all her masters. That's because she could control the publishing rights, and she could basically say to the guy that owned her masters, "Fine, you have your masters. I'll create new masters, put them online, and everybody's going to listen to that." So there was a conflict there between master rights and the usage thereof, and because she could control her copyright. Remember, copyright was performance and reproduction also means fixating your work into a recording. She could control that. So sometimes there's a way around it. If she couldn't, yeah, then she cannot do anything because the rights were not hers anymore.
Yeah, just easy question. Could the presentation be sent to us?
Yes, definitely. And I'm going to do one more thing here. Because it might be, I will be sending it out. My contact details, which are nice to have on screen. If this works, 1 second.
And if not, we can always send them to everyone.
Yes. So maybe I'll just tell them. So if you follow me on Instagram, or I even have TikTok now with the Dance Advocaat, you can keep updated about all kind of legal news. And yes, I will be definitely sending the presentation. It's copyrighted, but you can use it for educational purposes.
Great. Before we'll give, well, let's give him a hand now. Let's give him a hand now. Sander. Thank you very much. Thank you very much. As always, we as creative persons are a sort of, oh my God, this is the law. Let me just make some music. And I see really at some of your faces that's really happening during this whole workshop. I don't mind, but guys, there's one thing. One thing that I learned in my whole music career is once I started to get to know, to learn more about rights, about who is making money on what, and what can be my rights, and how can I make money out of things, then my professional career started. Before that, I just made music, and a lot of other people made money on me making fun with my music. But from the moment on, I was working really seriously about these kind of things. Then my professional career started off and kicked off. And it's really, believe me, it's 80% of your work. If you want to take yourself serious, take these kind of things serious, because it will be 80% of your work. And if you're not into that, I'm really serious, then you should think about, am I the right person to be a professional musician? So think about that, because it's really, really important.